Okay. I'm going to stumble through what I learned in Constitution this week. Here's the topics: the different kinds of unions that Constitution created, powers of disallowance and reservation, territorial limitations, the Statute of Westminster, the Manitoba Constitution challenge to the charter creation, the repatriation of the charter, compact theory, constitutional law, symbiosis of constitutional principles, judicial review of the legislation, constitutional reasoning, money issues at Constitution, money issues now, and a few different cases: Edwards versus the Attorney General, Ronquilelli versus Duplessis, and Manitoba language rights. Let's get started. Monetary union is a common currency. So at Constitution, they wanted to create a common currency for all the provinces. A customs union. So you could, the feds had the power for customs and duties, and they would be charged as goods were leaving the country as opposed to leaving the provinces, which comes to our economic union, a common market. That's the freedom of capital, labor, and goods. Capital, labor, and goods within Canada. So those were the unions that the creators of the Constitution were trying to create. It's also worth noting that the federal government was charged with the common interests of all of Canadians, whereas the provincial government was given the power over local interests. So disallowance. Section 90 of the Constitution says that Parliament has the powers of disallowance over the provinces for 12 months after a bill was passed. Why is this? Because as soon as the unions or the colonies came together to create Canada, the provincial governments thought that they were still omnipotent, and they were passing a number of laws that were unconstitutional. There was also the fact that Nova Scotia wanted to secede from the Union, which was not allowed, of course. So initially, this power was used a lot, though it's not at all used today. Now, the provincial politicians didn't like this at all, so there was kind of a give and take of provincial politicians understanding what's constitutional, and in the process complaining, and the federal politicians, giving to that pressure as well. What is reservation? Reservation is royal assent not being granted to a bill, and it's not been used since 1930. Now, the power of disallowance has now been replaced by judicial review because the politicians don't want to use the power of disallowance. It's very controversial. They'd rather just hand it off to, or hand that hot potato off to judicial review. Territorial limitations. There are the provincial legislation has territorial limitations. It's to the high tide line, I believe. And the federal legislation has limitations in that, I guess it's not limitations. They're in charge with international shipping lanes or shipping lanes, anything below the high tide mark, and I guess all across Canada. The reason, or the important reason for talking about territorial limitations, though, is the extraterritorial powers and the Statute of Westminster. It was the Statute of Westminster in 1931 that ended the unified crown and ended the fact that we were all British subjects in Canada, and created new powers for the Commonwealth countries, including external sovereignty. So the power to sign treaties, the power to act internationally with independence. It also changed that now the Canadian Crown is advised by provincial and federal legislatures instead of England, so the lieutenant and general governors. This brings us to Manitoba Constitution Challenge. The repatriation of the Constitution in 1982 was challenged by Manitoba. They wanted consultation and thought that consultation should be an important process of any change to the Constitution. So does consultation need to take place in order to amend the Constitution legally? Yes, absolutely. But the the repatriation of the charter was just a request to the United Kingdom. So it was allowed to go forward. Now, is it conventionally unconstitutional? Yes, conventionally, changes to the Constitution required unanimous decision. However, the Supreme Court decided in this case that a majority was good enough. Now, even though Manitoba was challenging the repatriation, it was Quebec who ended up being the only dissenter. However, they do not have veto power over the repatriation of the Constitution, and it's worth noting that if they did, they gave it up by agreeing to the Victoria Charter. Compact theory. This is a tiny political theory that says provincial power usurps federal power in the way that the colonies acted together to create the federal government. So the feds serve the provinces. But the Supreme Court said that's nice, but that's not the law. The Constitution says otherwise. Constitutional law is, just to define it, all statutes named in the Schedule of the Constitution Act, common law, and constitutional convention. So it's those three things. And it's worth noting the issue of constitutional supremacy. Section 52 of the Constitution Act. I'm just going to find that. States that this is the Constitution Act of 1982. The Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is to the extent of the inconsistency of no force and effect. It's also worth citing with regards to constitutional supremacy, the Urick Estate, where it was decided that the principles cannot alter the text. The implicit principles should expound the Constitution, and these are the principles on which the Constitution is founded, such as federalism, constitutionalism, democracy, the rule of law, and the rights of minorities. So these principles work in what is known as symbiosis. They work together as the foundational principles of the Constitution. So, for example, democracy is valuing everyone's opinion and everyone gets a vote, but is it the tyranny of the majority? Can 50 plus 1% of us decide that all people with blue eyes should be forced to work 10 hours a week for the state? No, of course not, because we also have respect for the rights of minorities and respect for the rule of law. So all of these principles work together. So federalism, is there unlimited federal power? The residual powers of the government should lie in the federal government. They have power over the common interests of the people, but is it unlimited? Absolutely not, because we have the Constitution, which guarantees powers to the provinces, and this is in part because we respect the rights of minorities. And when you look at Quebec secession, you can see all of these principles play out. Quebec wants to secede unilaterally. They can't, because we have the Constitution, because we have federalism, and because we have democracy. And the rule of law, I guess maybe that would refer to the amending formula in the Constitution. And we have the rights of minorities, which gave Quebec a cultural majority within their province and certain autonomy within the province. I shouldn't say we gave Quebec that. It was decided that that is how anyway. Judicial review of legislation. So superior courts only can review legislation, such as the Queen's Bench or the Supreme Court. Other boards and tribunals created by statutes cannot act outside their jurisdiction. For example, in the Duplessis case, the commissioner of the Liquor Control Board, or its equivalent in Quebec in the 1940s, revoked a license for purely political reasons. But the point here is the superior courts only can review legislation. Constitutional reasoning. So when interpreting the Constitution, there are a number of approaches to determining what its intent or purpose is. First is originalism. So the Constitution has a fixed meaning and it can't change. It means what the original writers wanted it to mean. When we look at contextual, we just read them and understand them as we do. So if we're modern people reading it, then we understand it in the context that we're in. Doctrinal is looking at precedents. So how did judges interpret this constitutional article 20 years ago? And it, in a sense, relieves you of the responsibility to interpret it. You just rely on precedent. And this is used in almost all of the constitutional interpretation cases, with the exception of the ones that require, well, not require us, but where the judge expands the law. Prudential involves a cost-benefit analysis regarding, alternative interpretations. Ethical reasoning is to protect the vulnerable, and it links to foundational principles. And a structural interpretation empowers the principles of federalism and democracy. So the principles can be used to interpret the statutes, but they cannot be used to change the wording of the statute. Money. Money at Constitution. What did the provinces get through Constitution? They got mineral wealth. They got the rights to all the mineral wealths in the province. And that was because it was thought that settlers would come and extract the mineral wealth and the provinces would be wealthy. It was also because some of the provinces, Nova Scotia, New Brunswick, they can't expand anywhere. So they need the wealth that is within their limited land. A clean economic slate, all of the debts from the provinces were taken over by the federal government, and New Brunswick and Nova Scotia, for having less debt than the provinces of Canada, or province of Canada, they received interest on the difference between their debt and the province of Canada's debt. They also receive an annual payment for the legislature, which is tens of thousands of dollars at the time, a head payment of 80 cents per person, the powers of direct taxation, and actually this wasn't our constitution, but it relates to what the provincial governments get. Out west, they got land accretions added, so the original province was a certain size, and they were given more land as the country expanded westward. But the the provinces in the east weren't able to expand, so they were given offshore accords or rights to water resources or fisheries resources. So a constitution, the province of Canada ended up getting a pretty good deal. They gave up 60% of their revenue and got back 77%. Nova Scotia, on the other hand, gave up 80% of their revenue and got back 45%, and New Brunswick gave up 78% of their revenue and got back 49%. So it's worth noting that some of these issues, or some of the advantages they received very shortly afterwards turned out to be not very valuable. Money now, about 35% of the provincial budget is transfers from the federal government. And many of them are conditional transfers, so they need to be used for certain things. They can't be used for anything. Of course, the provinces would love unconditional transfers, but that's not the case. We have the Canada Social Transfer. This is for children, post-secondary and social programs. It is given on a per capita basis, and it was $11.9 billion in 2013. The Canada Health Transfer is funding for healthcare. Again, this is per capita, and you can receive it in a cash or tax point transfer. If you're a smaller population, the tax point may not be worth very much, so you want the cash. And that was $29 billion in 2013. And these are grounded in the principle of equal citizenship. So we all have the right to equal health care and education no matter where you are in Canada. Equalization payments, these come from federal revenue. They are controversial and revisited every 5 years. And they are determined by looking at the revenue of the province, dividing it by the population, determining an average around the provinces, and if you're above the average, you give money, and if you're below the average, then you receive money. The head provinces right now are Saskatchewan, Newfoundland, Alberta, and BC. It's also worth noting that Quebec will never be a head province. They will never be giving money to the equalization formula and receiving less back. And that's a political decision, because if they are giving and not receiving, then it's going to flame the fires of cessation. The provinces also receive payments in lieu of taxes. And this is, according to the Constitution, the federal government doesn't have to pay taxes for their properties in the provinces, but they do anyway. And this is to stop anyone from objecting to another federal building going up or the federal government buying certain properties. So the annual financial report of Canada, 48% of the revenues from personal income tax, 13% from corporate income tax. The GST brings in 11.6%, and there's other revenues from Crown corporations brings in 11%. EI premiums brings in 7.6%. Where are they spending their money? Transfers to people is 25%, and transfers to other governments are 20%, and other transfer payments are 12%. So almost 60% of the budget is transferred. Their operating expenses, not including defense, is only 18.3% of their budget, and 11.5% is spent on public debt. Transfers annually per capita. So due to the social, what are they called again? Equalization, the health transfer, and the social transfer, and other transfer agreements, the federal government gives money to provinces, and they give more to some than others. For example, the lowest is Alberta. They receive $973 per person in transfer payments. The highest is Nunavut, where they receive $39,000 per person in transfer payments. New Brunswick is on the higher end, probably one of the highest of the 10 provinces, at $3,293 per person, and it appears Prince Edward Island is the highest with $3,487 per person. Looking at the New Brunswick budget, they receive $4.8 billion in taxation, royalties, and fines. And they receive $2.7 billion in grants from the federal government. Their budget is $7.5 billion. Federalism and money. The key points: transfer payments and the expectation that people will move to areas of economic growth are the costs of federalism, but the benefits are better. So transferring money between the provinces or the costs is a cost to the provinces if you have money, I suppose. And people being uprooted from areas of low economic activity and having to travel to areas where there is economic activity, so freedom or mobility of labor, those are costs of federalism, but we do receive some benefits. It's worth noting that every so often people argue that the provinces should look after themselves. Why does the federal government collect money and divvy it out for education, for example, when that is a provincial responsibility? They can do that, but they cannot legislate in education. So they can create a pot of money and give it conditionally, but